The applicant, Mr. Gillham, is a concert pianist. He contends that the Melbourne Symphony Orchestra, the MSO, took adverse actions against him in August 2024, contrary to Section 340 of the Fair Work Act, and that Mr. Ross, the MSO's then Chief Operating Officer, was knowingly involved in one of those contraventions. The claimed adverse actions were taken after Mr. Gillham made statements that Israel had committed war crimes by targeting journalists in Gaza when he was introducing a new piece at a piano recital presented by the MSO on 11 August 2024. The MSO's actions were: 1. On Monday, 12 August, the MSO cancelled the scheduled performance by Mr. Gillham at a concert presented by the MSO scheduled for 15 August 2024. This is the cancellation. 2. On Monday, 12 August, the MSO emailed a message to those who had attended the 11 August recital, stating that Mr. Gillham would no longer be performing at the 15 August concert and apologising for his statements. This is the cancellation message. 3. On Wednesday, 14 August, the MSO sought to impose through Mr. Ross, as a condition of Mr. Gillham's performance on 15 August being reinstated, that, quote, there be no physical or verbal statement from the stage, close quote. This is known as the second condition. 4. On Thursday, 15 August, the MSO emailed and published a statement about the, by then cancelled, 15 August concert, which, among other things, did not contain an apology to Mr. Gillham for having previously cancelled his 15 August performance. This is the final public statement. Although these events are bound up with the Israel-Gaza conflict, it is not any part of my role to enter upon those matters of considerable public controversy. Mr. Gillham's claims against the MSO raised three broad issues. The first issue is whether Mr. Gillham had a workplace right within Section 341(1) of the Fair Work Act. Mr. Gillham says his workplace right is the right not to be treated unfavourably in the workplace because of his political belief, contained in the Victorian Equal Opportunity Act. Mr. Gillham says the Equal Opportunity Act is a workplace law for these purposes. I find that the Equal Opportunity Act is not a workplace law as defined in the Fair Work Act for two reasons. First, Mr. Gillham was an independent contractor of the MSO. The Equal Opportunity Act, in its application to him, was therefore not a law regulating the relationship between employer and employee as required by the definition of workplace law. Second, the scheme of the Fair Work Act is that state anti-discrimination laws, such as the Equal Opportunity Act, apply of their own force, supplemented by specific anti-discrimination rights in the Fair Work Act. It would be contrary to this legislative scheme to treat the Equal Opportunity Act as a workplace law so as to reapply as federal law the workplace discrimination provisions in the Equal Opportunity Act. The second issue is whether the four actions set out above are adverse actions within Section 342 of the Fair Work Act. The MSO admits that the cancellation is an adverse action, but says that its other actions are not adverse actions as defined. I find that none of the MSO's other three actions is an adverse action. None of these actions altered Mr. Gillham's position as an independent contractor to his prejudice. That position refers to the existing advantages of his previous engagement as an independent contractor, whereas these actions were all taken after that engagement had been terminated. Mr. Gillham contends that the second condition and the final public statement also discriminated against him in the proposed contractual terms and conditions. That argument is also rejected. On the facts, the second condition did not discriminate against Mr. Gillham, and the MSO was not proposing to enter into a contract with Mr. Gillham by the time of the final public statement. The third issue is whether the MSO's actions were taken because Mr. Gillham had or proposed to exercise a workplace right. The onus is on the MSO to show that Mr. Gillham's workplace right was not a substantial or operative reasons for its actions. My reasons on this issue are underpinned by three findings. First, I find that the MSO did have a policy of not expressing support for either side of the Israel-Gaza conflict. The description of that conflict in the MSO's policy might not be neutral, but the MSO was committed to not supporting either side. Second, I find that there is a custom or practice that classical musicians do not make statements on sensitive political or social issues from the stage without approval of the host. This custom is not universally observed, but that does not mean there is no custom or practice to begin with. These first two matters help explain the MSO's subjective reasons for the actions it took. Third, I find as a matter of law that the test of interconnection proposed by Mr. Gillham is not the test for determining whether action was taken because of a prohibited reason. Applying those findings, the political content of Mr. Gillham's remarks was not a substantial and operative reason for any of the MSO's actions. The substantial and operative reasons for the cancellation and the cancellation message were to address the anticipated adverse impacts that Mr. Gillham's remarks would have on the MSO's business and reputation. The substantial and operative reasons for the second condition in the final public statement were to address the adverse impacts on the MSO that had arisen from cancelling Mr. Gillham's Thursday performance. I find that the MSO would have taken the same actions if Mr. Gillham had expressed a political belief in support of Israel, or if Mr. Gillham had made statements on any other topic that had the same impact or anticipated impact on the MSO's business and reputation that Mr. Gillham's actual remarks had. These conclusions mean that Mr. Gillham's claims against the MSO must fail. It follows that the associated claim against Mr. Ross must also fail. A copy of the reasons for judgment and orders will be emailed to the parties.